Hello, everybody. I'm Phil Brandt, President and CEO of AIM Employers Association, and welcome to This Week at Work.
Welcome to This Week at Work, the only show to pack workplace news, practical HR solutions, and timely insights into every 30-minute episode. From the latest rulings in the courtroom to the strategies unfolding in the boardroom, and from real conversations taking place on the front lines to spotlighting what similar companies are doing about the challenges they face. This Week at Work brings you the conversations that matter most to HR professionals and business leaders like you. Brought to you by AIM Employers Association and Ogletree Deacons, live every Thursday morning. This is your opportunity to connect with their experts and ask your burning questions. So what's keeping you up at night? Let's face it together now on This Week at Work.
All right. Welcome back, everyone. Happy New Year to everyone. And you too, Bert. How are you?
I'm doing well. Happy 2025. I like the sound of that.
It is already 2025. I heard today on the radio driving in, and it made me reflect for a moment. Today marks a new generation of people being born, and I guess they called it generation, what they call it?
Beta.
Beta, yeah, generation beta. And I always thought of beta as like a test. I don't know if it's like a test generation. But anyway, the interesting fact is children born today and for the next, 15 years or so, I guess, as generations go, the majority of them most likely will live out of this century.
Crazy.
Yeah. Yeah, isn't that crazy to think of that? They'll see the turn of the next century. So quite amazing. And I'm expecting 2 grandchildren in this year. So 2 betas. We'll see how that comes along. How was your break, Bert?
My break was largely nice. We had a trip canceled. I had a little bit of a emergency health issue that's hopefully in the rearview mirror, and looking very forward to 2025 and putting 2024 in a box and wrapping it up in a box and putting it on a shelf.
Yeah, well, at least they're not wrapping you up in a box and putting you on a shelf, all right?
Exactly.
So we're glad that you're here with us, and I'm glad things are going well for you. I think if we went any further and we didn't, express any concerns and condolences and just utter shock for me with the news yesterday, waking up and what's happening down in New Orleans and even out in Las Vegas, reminds us the world we still live in and the times that we live with. But man, my heart just goes out to those poor people down there that have all been affected by that. It's just horrible tragedy, horrible, senseless,
sure.
Absolutely senseless. Yeah. Anyway, we got lots going on, Bert. We're going to introduce a new segment to the program in 2025, and it's called Burning Questions. Because as you and I know, but maybe most of our listeners know, we get lots of questions that are submitted to us throughout the program and off air that come in after hours. And we thought we might share those questions with the listening audience and share our responses with those. And we always want everyone to participate if they can. If you have a burning question, something you're dealing with in the workplace and you'd like to kind of get a perspective from Bert or I, you can always submit that question by hitting the question mark there, and we'll take a look at that and we'll try and address those and give you some perspective on it. And some of them are quite interesting and others are really quite difficult, but we'd appreciate any assistance you can give us by submitting your burning question, and we'll do our best to try and give you some insight on that. But Lawyer on the Clock is still the #1 segment on the program, Bert. Are you ready to kick us off with Lawyer on the Clock?
I'm ready. There's lots to talk about in this new year, Phil.
All right. Well, this is my favorite part. Nick, pull that lever.
Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
So, Phil, I'm going to just talk about a few new state laws that all HR folks should get familiar with, and then when I get past these first few, I'm going to talk about Illinois in particular because I know we have a ton of listeners who are in Illinois or have Illinois operations. So there's several new laws that are taking place in Illinois. The first one I'll start with, of course, is the Missouri minimum wage. We know that the Missouri minimum wage increased as of yesterday, $13.75, I believe.
1375, yeah.
Is that number. And now we know we have the looming Missouri sick leave law. Now there has been litigation filed over this entire law, the minimum wage piece, the sick leave piece. But the courts, I know you had a guest on in my absence a week ago or a couple weeks ago, and the lawyer who was on is the lawyer that actually filed the litigation challenging the legislation itself. Nothing happened the last 2 weeks with that lawsuit. No courts have stayed the increase in the minimum wage. I think the real focus of the lawsuit is the sick leave portion, and that's not set to go into effect until May. And so I do think we will hear from the courts well in advance of that piece going into effect, whether it will actually go into effect or not.
Yeah. So the advice is you have to change your minimum wage, $13.75. Let's not fool around with it, and then we can work on where we go next with what we understand that comes out of the court system. Yeah,
that's exactly right. So some quick hitters for you, and I'm mentioning California and New York in particular because those states are quite aggressive and progressive in their employment laws. And what they do is they hope that employers who are operating across the country nationally sort of say, all right, if we have to do this in California or New York, we'll just adopt this for everywhere that we have employees. And they hope to force change, even though the laws are limited just to those states. They hope to force employers or encourage employers to adopt these sweeping protections. So the first one is there's a new law that went into effect in California that breaks ground on what's called intersectional bias. And that updates existing laws that prohibit discrimination.
Wait, say that in. What is intersectional bias? All
intersectional bias.
What does that even mean?
I'll get there,
okay.
Phil. You know I will.
All right.
So it updates their existing laws that prohibit discrimination in employment, housing, public accommodations, and education to state that those laws also forbid bias based on a combination of two or more protected characteristics. So while this law probably doesn't really actually change that much on how the law is interpreted, it just makes it that parts of the state's laws that bar discrimination on protected characteristics, race, sex, religion, sexual orientation, and national origin, it creates an analytical framework that sets forth the different forms of inequality operate together to exacerbate each other and can result in amplified forms of prejudice and harm. There's the answer for you, Phil. Do you know what that means?
You just don't discriminate, and I think we're okay. I mean,
Yes.
it's just that easy to me. I mean, having two or more, you're not supposed to have one or more. So it just keep it simple if we break it down. But
yeah, I think in practice, it's probably not going to change a whole heck of a lot, but just be aware that that's out there. Moving across the country in New York. New York is expanding its paid sick leave mandates to include a new bank of 20 hours that pregnant workers can tap for the purpose of obtaining pregnancy-related medical care without them having to dip into their existing allotment of paid sick time. So this is a new bank of time for New York employers.
And that's paid time, yes?
Correct. Paid sick
time. So pregnant workers get an additional 20 hours of paid time for pregnancy care.
That's exactly right.
Okay.
Right?
All right.
Let's go back out to California. California also has a new law that went into effect yesterday that expands workplace protections for people who are victims of violent crimes or abuse and allows them to take job-protected leave to help family members who have been victims of violent acts. So just know that that one's taking place out in California. Connecticut, going back across the country, is this one, they've really expanded their state's paid leave sick requirements. Businesses that employ 25 or more workers must begin complying with the sick leave law this year. Next year, employers with at least 11 employees will fall under the state sick leave law. And then in 2027, businesses all the way down to those with a single employee must be in compliance, like I said, in 2027. So that
if you
just kind of
single
shows those
employee,
trends.
if I work for myself, I have to give myself sick leave, yes?
Exactly. Mandatory paid sick leave for yourself, Phil.
I like it. Hey, I
Yes.
mean, it's just getting out of control. I'm all for sick leave. Don't get me wrong. I'm not against sick leave in this, but it's the ridiculous approach that we take. Yeah.
Yes. Yes. All right. So then let's shift gears and let's focus on Illinois. We've talked about Missouri. We've talked about some of the trends across the country. Let's really focus on Illinois now. So Illinois has a law that just went into effect called on the subject of caregiver provisions, and it makes it unlawful for employers to discriminate against or harass employees based on their family caregiving responsibilities. So the legislation adds family responsibilities as a protected class under the Illinois Human Rights Act. It makes it unlawful to refuse to hire, deny a promotion, or discharge an employee based on the employee's actual or perceived responsibility to provide personal care to a family member. Okay, so that's pretty expansive.
Okay. So this is break that down just a little bit. So an employee who has to give care to a family member, and you're talking about where they work in the same place?
No, I'm talking about if they have to care for a child or if they have to care for a parent. I believe the legislation says if they have to provide personal care to a family member, then that is a protected class. You cannot discriminate against somebody who has to provide that.
Okay. And that would be outside of family medical leave
Correct.
or in
Because family
addition
medical
to,
leave is
yeah,
federal, of course, and this would be a state law. You
state.
just can't discriminate against them or harass them based on their family caregiving responsibilities.
And make sure it's not intersectional.
Yeah, well, that would be California, yes. So,
I'm just making my point of craziness here. It's the new year. I still feel a little giddy from New Year's Eve. So
yeah,
you keep going. I'm not trying to throw you off here, Bert.
that's all right. The hard part with this one's going to be, of course, when you have an employee who's absent from work because they have quote unquote family responsibilities. Can you take adverse employment action against them? And that's going to be the hard part in dealing with that piece of legislation.
Yeah.
For anyone who wants to look that up, it's House Bill 2161. There's also another House bill that was passed and signed into legislation, and that prohibits Illinois employers from discriminating against employees for actual or perceived reproductive health decisions. The law defines reproductive health decisions broadly as a person's decisions regarding the person's use of contraception, fertility, sterilization care, assisted reproductive technologies, miscarriage management care, health care related to the continuation or termination of pregnancy or prenatal, intranatal, or postnatal care. So just be aware that that one exists out there.
That one seems to have, I want to be careful in how we tread into this because we're always trying to be careful in this, but is there an element of transgender care in that? Do you think? You start
I don't know.
peeling that back and the way you describe that, I also think I might at least have that in my mind over here, as you're reading the reproductive care.
Yeah.
Yeah.
That I'm not sure if that'll implicate any transgender issues. I'm sure somebody with some creativity will find a way to bring a claim under that. And again, I guess if a person was born a female and is now transgender, but has the proper insides to reproduce, then you could maybe end up with some sort of claim there, but that would be
Yeah,
speculative at this point.
sure. Yep.
All
Okay.
right, a few others in Illinois. Last year, there's a new child labor law that changes the hours that minors are allowed to work, specifies additional prohibited occupations for minors, and adds a provision prohibiting discrimination and retaliation. So be aware that the Illinois child labor laws uh, have been modified. Illinois also enacted a new law called the Worker Freedom of Speech Act, and that prohibits employers from holding mandatory meetings concerning religious or political matters, including discussions on union representation. My hunch on that one is that that's going to be preempted by the National Labor Relations Act. And if that gets challenged in court, I think that law would get stricken down. Illinois also amended its Equal Pay Act to require employers with at least 15 employees to include pay scale and benefits in all job postings. So keep that one in mind. And then the last one I'm going to mention here, Phil, is that there's a new law that went into place that creates several employment protections for individuals when employers use the federal E-Verify system. Employers that continue to use E-Verify must incorporate new requirements into their employment verification practices so that they do not impose work authorization requirements greater than those required under federal law.
All right. It's just like our state of Illinois just keeps on adding to it. I mean, it's getting so difficult. I really do have a lot of empathy for the leaders in Illinois who are trying to manage that. And I know, and working with our AIM members, I mean, they are just trying to do the right thing here. We're not trying to get over on the law. It's just navigating all of those obstacles as you go through to, making decisions. And I think it leads to a lot of the questions and complications that it gets to do business there.
It is very difficult. And
Yeah.
I think I'll just mention, Phil, real quickly, that if anybody goes out there and they Google Ogletree Deacons and then the title of a great article that was published 3 or 4 days ago by my firm, Key State Laws Set to Take Effect on January 1, 2025. It lists the key state laws in the various states and has actual links to the new laws that are going into effect, including all of those in Illinois. So anybody who wants to learn more, please go look at that article that's out there, click on those links, and maybe next week we can take some questions on some of those.
Yeah, it's and I know we've been navigating them quite a bit, but it is just complicated. And if you do have questions, you can always submit those as well to Bert and I by clicking on the question mark or barcode scan. Producer Nick's got all kinds of methods for you to participate depending on how you absorb our program, and we'll be happy to try and talk about those the best we can and bring some clarity to it. All right. Anything else there, Bert?
I think that's enough, Phil.
That's a mouthful for the year, if you ask me. But it's going to be a great year. I know we got a lot of good things going. We got the new segment we want to introduce, Producer Nick. Burning Questions is our new segment, and this is where we're going to take some of the questions we get through AIM here and on the program and try and bring them to life for you and give you a little shade of color on those. I think we're going to have a good segment here, Bert. I really like this first burning question. Here we go. You like that? Look at the effects that Producer Nick has put in there.
Phil, do you ever have a burning sensation?
I don't know what you're talking about, Bert. We're going to keep this as a PG show, okay? All right. Okay, so here we go. This question, I've had to deal with this one several times. This is not an unusual question, but it does create havoc in the workplace, right? Googled or gagged, right? And what we have here is we have someone who is scheduled for an interview for a senior position in an academic institution, and someone on the team Googled the candidate and revealed that they had been arrested for domestic violence against a mistress and also had an arrest warrant out for him. So what should we do? Should we bring him in for the interview as it was scheduled? And now I can tell you that's not the first time I've had that question. The extremes that people go through to find out who you're interviewing and to give you your opinion before you've ever talked to them is quite an extreme. I've even seen it where they go up to the registry desk. You know, you walk in, you sign your name in. And they read the names off of the people who came for an interview. They run out, they Google the people, and they start sending notes over to HR about the candidate. Did you know? And did you know they worked here? Did you know they did that? Did you know they had this arrest record? But so it does, this is not an unusual question, but a great question to address. Bert, in your opinion, someone brings you some information. What I want to say is they have an arrest record, but it doesn't mean convicted, right? And we usually make our decisions based upon convictions and length of time of conviction and the seriousness of the conviction and the relative nature of the conviction to the job. And does it get in the way of the job? So academic, been arrested does not say been convicted for domestic violence and has a warrant out for the arrest. How would you proceed?
Yeah, so this one you really need to be careful with, obviously. And Phil, you properly bring up a good distinction between conviction and an arrest. The EEOC and most of the court decisions that are out there take the position that a conviction is a relevant inquiry or area of inquiry when you are considering somebody for employment. Now, the timing of that is important. Most questions regarding convictions should be done. First of all, this needs to be done on an individualized basis, where you look at, like you said, the nature of the crime, the nature of the conviction, the job relatedness of the conviction, the time since the offense, those types of criteria. Most inquiries on conviction should be done post interview, but pre-offer. And so you shouldn't be weeding people out, according to the EEOC, at least in some of the court cases, based on simply a conviction. You shouldn't be weeding them out from the interview process. Okay, so post-offer, pre-employment is the time to really dig in. It's kind of when you would do that background check on the individual. That's really the timing of that. So again, post-offer, pre-employment is when you would look at that. Now, I do think that there's a difference between somebody who has an arrest and then wasn't convicted over time versus somebody who has an active arrest or an active warrant out there. And so my suggestion would be, I do think that, now that we've been armed with this information, I think that we should ask the individual about the open arrest warrant and try to get some information and determine if it is job related or not. Again, arrests are treated very differently than convictions themselves, and the EEOC really takes a tough stance on employers who are making decisions based on arrests versus convictions.
Yeah, and I mean, if you take this, just peel back some layers on it, and you get into a lot of workplace challenges and problems, right? So you have also the scenario of, well, if you have an employee that is arrested for domestic violence, are you going to terminate the employee?
That's right.
Are you going to take action? And you get into this fairness and ability. Does it interfere with the ability to perform the job? I recognize this person's working in an education institution, so you're kind of exposed to the public, but it's really more about providing safety for your workers. And I think you have to start asking yourselves lots of questions before you take any particular action. Again, you appreciate the help from your coworkers and the the employment base at large, but it's not the help that you need. Particularly if you're going through the right steps, you're going to discover this by using Ames background checks or some other background check service that's going to make sure that you get the right information to make the decisions you need for employment. So I would tread lightly as well. But now that it is made available, I'm going to ask the questions in the interview. Is there anything I should be aware of, know about? This information has came to our attention, not because we did any research on it ourselves, but if it's an employee that did the research and the employee did the research on company time with company computers, I think you also could have some other problems by saying, well, the employer didn't, because that employee is acting on behalf of the employer, even if not instructed.
Yeah, it's one of those things, Phil. Once we kind of learn something, it's hard to unlearn it.
Unlearn it, yeah.
And so I would go a step further and just say that I don't see it coming up in the scenario of a conviction or an arrest quite as often as I see people going out looking at applicants at social media, and then they learn something about the individual's religious background, or they learn something about the individual's health, or age, or gender, and those are the types of things you just don't want to put yourself as the employer in a position of being accused of filtering people out based on protected characteristics. So again, I think the timing of a lot of this is important. That a lot of this is done post offer, but pre-employment. That's the timing, and then again, that individualized analysis there, making sure that whatever you learn from the social media is job related.
Yeah. Yeah, that's a great burning question. Hopefully we gave some good insight on that. You got time for one more question, Bert?
Of course.
All right, good. I got one more burning question here. Let's look at this one is also not too unusual. I've dealt with it a few times, and it's got to do with drinking and driving. So it's the driving dilemma. A manager was stopped for driving under the influence. It doesn't say what the influence was. Lost her license. She is required to travel for the company between buildings and sites. And the question is, can they allow her to use Uber, or what else can they do? And I think, my first thought is whether or not they're traveling between sites on company premise, do you normally allow Uber or a third-party driver in that as one consideration I would take? Because I know in scenarios where I've had large sites that I've managed where you would drive between buildings but staying on company premises, we would not allow third-party vehicles for the purposes of safety, security, and other reasons on property. But that is an option, but it's not unusual for someone to get a driving under the influence and a suspended license and then struggling to find a way to get to work from work. They have to travel and drive for their job. And sometimes you are able to get an exception that allows you to get a license to drive only while working and for the purpose of working. But in this case, it sounds like maybe not.
Yeah. Yeah, I think so. So let me start with let's presume with this question here, Phil, that this is not a situation where the individual suffers from alcoholism and has brought this to the company's attention previously, because that would have some ADA implications for us.
Yeah, good point. Yeah.
And so let's presume that that's not the situation here, that this was like a one-time situation where the individual was stopped for a DUI, lost her license. There's not alcoholism involved. There's no ADA implications. And so the question is, so in that situation, if it was an ADA situation, we would need to consider perhaps reasonable accommodations, which could be to allow the individual to use Uber. We may not ultimately approve that accommodation, but that's something we should at least consider.
Yeah. The interactive process, as you would tell us.
Yeah. Exactly. But in this situation here, where this is probably just a one-time situation, there's really not much for us to accommodate. And if she can't perform the essential functions of the position, again, using that language, even though we're not in an ADA situation, if she can't perform the essential functions of the position, such as going from location to location because she lost her license, we would be treating her hopefully the same as anyone else who lost their license for any other reason, that they didn't renew it, they lost their insurance, whatever it is. And we're not discriminating or doing anything against this individual because of the DUI per se, but really because they can't perform the essential functions of the position, which would be driving from location to location.
Right. And so other things to maybe consider, I know in dealing with some of this myself, is can I reassign the manager to a different job that, accommodates a time period, and not for ADA purposes, just because maybe I have a manager that I want to retain who's valuable to us. And we want to find a way to make this work. And that's another consideration, is reassignment during this period, or for even a longer period if necessary, in that scenario as well. But there you go, Bert. There's a couple burning questions. I'm happy we got a chance to help people out there.
Absolutely. And just remember all of our listeners and viewers, you can ask your burning questions anytime, and we can cover those during the next show.
Yeah. All right, Bert, I'll tell you what, I'm looking forward to a fantastic 2025. We got producer Nick in the studio, is really amping things up. It's going to be a good year. There you go, producer Nick. It's going to be a good year. Looking forward to another 52 episodes with you this year if everything goes right. And we will be back here next week at 7:30 Central Time. We'll see you then. Bye-bye.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please like it, share it, and make sure it's on your calendar. If you're an on-demand viewer, don't forget you can be part of the show by watching live at 7:30 a.m. Central every Thursday morning, when you can get your burning questions answered by using the question mark icon to the right of the player. In fact, you can ask a question now. Head over to aimea.org. Under Member Resources, you'll find This Week at Work. Click Listen Live to register for our next episode and submit a question. Or follow or subscribe wherever you get your news and entertainment. We'll see you next week when we discuss what's happening this week at work.